Welcome one and all. My name is Sarah Kanaan. I'm a master's student in international law and co-in charge in Mediate Guru Lebanon chapter. Welcome to the 6th International Workshop on ADR. The session will be tackling mediation secrets for better business negotiation, top techniques from mediation training experts. About Mediate Guru is a social initiative led by members across the globe. The aim of the organization is to bridge the gap between general public and litigation. We are creating a social awareness campaign for showcasing mediation as the future, having successfully conducted various international webinars promoting alternative dispute resolution, having a reach in more than 60 countries around the world with an international family growing each day. We strive to provide you the best lecture series through the best speakers around the globe so that you have a value addition today. I feel honored today to welcome our esteemed speaker, Dr. Salam Abdel, attorney at law, PhD and CEO of Salmas law firm, legal immigration consultant, human rights and United Nations expert immigration certified attorney from Canada, Europe, USA, International Associate of AILA, Washington, USA, member of UIA Paris, France. Thank you so much for joining, everyone. Without any further ado, let us begin. Dr. Salam, I request you to take the session forward and enlighten us all. You all can ask your questions in the chat box. Dr. Salam, the floor is yours. Dr. Salam, you can start your presentation. You can start, Doctor, presenting. Can you hear me?
You are hearing me?
Yes, we can.
Yes, okay.
You can start.
Okay, so hello all. Please let me know if my voice is not clear enough or you have any trouble while hearing me, because I think this is my time to start. So if it's okay, then I can proceed, yeah? Great. Oh, great. Okay. So first of all, before starting our trip with the mediation, this important topic so far, let me first of all thank a lot the organization and the organizers, especially Ruba, Sarah, Sasha, and all the team that worked already and is working to make this event successful. Thank you all. Thank you as well for hosting me to make this this speech. It's an honor and it's a big pleasure. I think the time that is given to me to explain or to speak about the mediation is a little bit short, because I know the mediation as well as the arbitration and the conciliation, those three topics are very very interesting and very necessary to have an idea, and even though to make some specialization about them, because as you know, first of all, most of people are escaping the state courts. Second, the pandemic which are facing, and I mean exactly coronavirus, let most of the justice or state court close their doors in front of the litigators. So we don't have any other option than to go to alternative dispute resolution. And one of those alternative dispute resolution is the mediation. For sure that I will not give a lecture as I did and as I do usually in my classes in the university where I'm teaching this topic, because I know you are more than students, you are professionals, you are careerists, etc., etc. But I will try to summarize, first of all, the importance of the mediation. This is one, the steps to make a mediation successful. Two, and what is the benefit to have such mediation, and what is the need to go to the mediation. So what about the definition? What about the definition? As all of you know that when we are talking about mediation, so we are out of the justice, out of the circle of the justice. So now we don't have a judge. Okay, we have lawyers for sure, but we don't have judges. We don't have the state interfering, the government interfering. So we are in the private area, in a private sector. But at the same time, the consequence and the effects, okay, arise from this mediation, okay, has the same effect, because we can go and we can implement the effect. We can settle the dispute as the judge does. For the moment, the definition, as all of you know, that the mediation is an alternative dispute resolution. So without any doubt, okay, this is a better way to resolve the dispute comparing to any other mean for settlement. What is the definition? And it's clear. We can also define the mediation through the elements which are constituting, which are constructing the mediation itself. But in two words, we can say that mediation is an alternative resolution, or it's an alternative dispute resolution leading or aiming to settle a dispute. But and this is very important to know, the mediation is not like arbitration. Mediation is not like conciliation. Mediation, for sure, and with evidence, is not like a judge or a state court. So this is for the definition. Why people refers, or why people go usually to the mediation, as I told you before, first because they don't like to go at this stage, at least, to go to the government, especially to the justice, to the state court. Okay. Second, they also will not want to go to the arbitration. They need to settle the dispute between them. Okay, so we are on an informal stage of dispute or of settlement. This is very important. And if we want to localize the mediation as means of alternative dispute resolution, it it comes, no doubt, in the middle, because first you have the conciliation. Conciliation, anybody can speak with any other people. If they are in dispute, then they can speak together, trying to find out a solution. So conciliation, conciliator. Okay, so this is the first phase of the alternative dispute resolution. But if they want to formalize, or if they want to settle their disputes using not official and not formal means, but at least using a process, using a procedure, okay, which is not obligatory, which is not official, with official nature, then they will go to the mediation. So in 2 words, the mediation is an alternative dispute resolution which comes, okay, between the conciliation and the arbitration. So why we will go to the mediation? As I explained before, and as I told you previously, we will go to the mediation because we want to make it between us. We want to settle the dispute, okay, between us, but at the same time, according to formal rules. Yes, I can say that we are facing firmer rules. Why? Because now, and I can say, for example, in Lebanon, unfortunately, we don't have special legal text organizing the mediation, while in France, a couple of years ago, even more and more, I mean even earlier, also in Europe, in the States, in India, and Far East countries in general, yes, mediation is organized. It is organized by the law. So we can say, for example, we need to settle the dispute according to the mediation. Then we have to apply, okay, the mediation process, the mediation rules on such dispute, which means now it's organized by law. Okay, so what is the presentation? Because I made some notes, because if I want to go through a mediation process, maybe take us, as I told you before, more than 2 hours. Maybe we need sessions and sessions, because as you know, it's very interesting to know the mediation. It's very interesting to catch the different elements of the mediation. But you know, now we are we are in just 45 minutes a session, and we need to rise up the important notes or the important factors of the mediation. That's why I made some notes so far, and I want to present, okay, the legal points related to the mediation as following. First of all, we have, so to make a definition, and we already defined the mediation. Second question or second topic, what are 5 steps of mediation? No doubt that the mediation requires 5 steps. Okay, so we have to pass through 5 steps. So 3, and I will explain for sure every single note. 3, what is the role of the mediator in the conflict resolution? You know, the mediator, so he is the man or the woman, let's say the person in charge to settle the dispute according to the mediation. So this person is called the mediator. 4, what are, let's say, the steps to make the mediation successful? How we can success in our mission as mediators or as litigators, okay, in a mediation story or mediation procedure. Because we are going to settle a dispute according to the mediation without reaching the output that all of us is working after, then no need to go to the mediation. If we will see, for example, that mediation will refer us to the arbitration, then why to waste our time? okay, we will go directly to the arbitration. Okay, if we know that, for example, we are mediating a dispute, and at the same time we need to know, or we will see that such dispute will be referring to the justice, the evidence exchanging during the mediation will be brought also in front of the justice. So also no need to go to the mediation. It's very important so to tackle those points. That's why I will do my best, okay, to explain and to make it as simple as I can. Okay, I will not complicate the presentation. I will not how to say it. I will not enlarge very much. Okay, the debate. No, I need it very clear, and I need it also very very strict. Okay, so and to the point. So regarding the definition, it's clear. No need to repeat. What are the steps of the mediation? Okay, I need you to know, okay, maybe most of you want, okay, to be a mediator, or are lawyers or professionals, and they want to represent their clients in the mediation, okay, because you know the mediation now, it comes out how to say it, an organized chapter of alternative dispute resolution. So it's not just a kidding, it's not just an act of conciliation. No, it's a between a bracket formal phase. Why between a bracket? Because we are all the time in an informal phase. Okay, please forget the formalism, forget also the officialism, because it's not official at all. At the same time, and before going to question number 2, okay, or to my second point in my presentation, I need to focus in a very important point, which is we cannot register any point debated or any question related to the mediation in order to be used in the arbitration, in order to be used in front of the justice. It's not allowed at all. That's why it's not allowed to write, if we want to make, for example, a minutes, okay, or a procès-verbal, as we say it in law, regarding, for example, the meeting of a mediation. We cannot write in, for example, pencil, which erasing is not possible, because we have to erase everything, and it's one of the conditions of the requirements, okay, relating to the mediation, because we cannot use the evidence, or use the discussion, or using the debate, okay, relating to the mediation in the next steps, I mean in the arbitration or in the state court. So it's very important, okay, it's very important to catch such remark. Okay, so I will read, okay, and very, very quick and very briefly. First of all, so one of the 5 steps of mediation. What are the 5 steps of the mediation? This is what we have to know. Okay, we can, for example, we have to make an introduction. Okay, we have to introduce the mediator or the mediators. Okay, we have to introduce the case. We have to introduce the litigators. I mean the parties. Then we have to state a statement of the problem. Okay, we have to say that the problem, for example, is focusing, or is about, let's say, a real estate, a property, a problem. So far, the examples are many, but we have to make a statement of the problem. So 3, information gathering. We have to gather all the information, because we cannot hide any information related to the mediation, because such information will attack or will make an effect on the outcome, final final outcome. It's very important to gather all the information, all the information. Any hidden information can destroy all our work. So for identification of the problem, once the information are gathered, okay, then we have to identify the problem. Okay, where is the problem? Where's the trouble? Why we are in a dispute? Okay, because we cannot settle any dispute, okay, unless we are identifying the problem. Okay, because why, for example, we have two litigators. Okay, what's the problem? Okay, it's what? It's question of what? Okay, it's a rent agreement. So where's the problem? Are you applying, for example, the rent law? It's what? It's a property, for example, in dispute. Okay, it's a purchase agreement, etc., etc. So then, once the information is gathered, we are identifying the problem. Okay, there's, for example, a problem about the property. I paid you all the amount. I paid you half amount, etc. You have to register the property on my behalf. So now we are identifying the problem. We are all the knowledge, all the information related to the dispute. Okay, we are as well making or putting on the table all the evidence and the proofs. Okay, we will reach the settlement. Okay, so we know everything. Nothing is hidden. Okay, then we can reach a settlement. So the settlement is very important because all our work, okay, should lead to a settlement. Otherwise, no need to make a mediation. So this is very important to know. So that's why, first of all, what is the mediation? Second, what are the steps of the mediation, which I previously mentioned them to you, okay? And for sure, in those steps, the most important is the settlement. You are not, and as I can see, you are not just law students, okay? I think most of you are professionals, are lawyers, are judges, etc., whatever. So all what we need, a practical solution, okay? This is what we call the settlement. Without settlement, no need to go to the mediation, okay? So if you finished the first point of my presentation, okay, the second point of the presentation, so still 2 points. And I insisted while I spoke with the organizers, which I appreciate them and appreciate their work, that I don't need to make a lecture like class room or at the university. No, I want some interaction. That's why I need to give you more time and good time also to make an interaction. So that's why I will have just 2 points in my presentation. So the one of those 2 points, that what is the role of the mediator in a conflict resolution? What is his role? So the mediator, if, for example, the output, okay, or the outcome to be reached, okay, from any mediation so far is the settlement. So the body, I mean, or the gentleman or the lady, because it can be done by a man or a woman, okay? Who is this guy to make the mediation? Is the mediator. So the mediator has a very important role in the mediation. That's why, and it's very important to know, and we will see now when we are talking about the 8 steps to make the mediation successful. The mediator should be a professional, okay, should be an ethical person. The mediator should know his rights as well as his duties, her rights as well as her duties in case we are talking about a female. So the mediator should be an experienced person, should be expert. And it's very important to know that for sure any person can be a mediator, but not anyone can settle, for example, a technical issue. If we are talking about a law dispute or a legal dispute, then we need a law, how to say it, not a lawmaker, but then we need a law professional. We need, for example, a lawyer, a judge, a notary, also a law professor, etc. But when we are speaking about commerce, especially the international commerce, international business, for example, throughout the world, then we need a technical or we need a commercial person, a commercial mediator or a mediator specialized in the commerce or in the international trade. So this is very important. What is the role? So the role of the mediator, okay, after or let's say besides his skills or her skills, okay, he has, okay, as we said previously, he has a very important role. So we know what is the role. The role of the mediator is settling, okay, or finding out the settlement or finding out the resolution, because without resolution we are wasting our time, and the resolution should be done or should be reached out, okay, how to say it, should be out in favor of both parties, of all the litigators, because we cannot enforce for sure in the mediation anybody to, okay, to carry out the settlement, okay, or the resolution, because as you know, we don't have the compulsory, we don't have the enforcement, we don't have the obligation, because we are, okay, in the stage, or we are not, let's say, between a bracket, out of the state stage or out of the execution stage. So we have to implement the resolution or the settlement on a good faith, or we have to implement it amicably, which is very important. Okay, we are not here in an arbitration. We are not an arbitrator. We cannot enforce anybody, okay, to implement the resolution. So we have to cooperate together, okay, which is very important, to cooperate in order to reach the solution. So, okay, finally, and also this is the final step or final topic in my presentation. Okay, what are the steps to make mediation successful? Okay, so we need, okay, to success in our mission. How? Okay, we cannot do it like this. It's an art. It's a science. Okay, the mediation. Okay, we can hear previously by a mediator, let's say on an amicable basis. It's okay. Okay, but now the mediation becomes, as the arbitration, a science. Okay, there are institutions, official institution, private institution. There are laws, okay, to organize the mediation. That's why we need to refer to several points or several steps to make the mediation successful. So I will read them because, as I told you, I need to restrict the debate, okay, because it's a very large topic. If you want to develop it or explain it further, it will take us more and more time. So 8 steps. What are the 8 steps to make mediation successful? The first step, to decide when to mediate. Okay, it's very important. Okay, we have to make a decision when to go to the mediation, because maybe we can be satisfied to make a conciliation. Okay, I can call, for example, the other party, the adversary, that come please. Okay, we can have a coffee and we can settle our problem. Okay, we'll say yes. Then no need, okay, to appoint a mediator. No need to go through a mediation phase. So we have to decide, okay, to have that when to mediate. Okay, is it the good time? Is it the appropriate time to go to the mediation, okay, or not? So this is very important, the timing. 1, Two, we have to learn about the mediator. And it's very important. We are not facing a judge, okay? Because the judge, we are pushed to go to the judge, okay, regardless his or her identity. Maybe, for example, the judge will be a young man, he will be an old man. Maybe the judge, for example, he is, for example, a professor at the university, etc. So we disregard any nature or any characteristic belongs to the judge, while in the mediator, he's one of us, or he's one like us, okay, or she is, for example, sorry for the ladies, okay, so she or he. That's why we have to learn up about our mediator. Who is this person? Okay, why not? We can know about him or about her, because it will help us to reach out a solution or a resolution, and it's very normal. Okay, because if, for example, okay, we know that the mediator is, let's say, is young like us. It will accelerate. It will accelerate the process, or it will accelerate the time, yes, to reach out the solution. So we can learn, or we have to learn about our mediator. Three, okay, we have to analyze the case early. So my friends, and I'm happy, yes, to consider you as my friends, because you know the friendship is very important, and for my viewpoint, it supersedes any other issue in the life, the friendship. So my friends, first of all, or first to go through the mediation, we have to analyze the case early. Okay, we cannot gather the information, put all the information on the table, okay, and identifying the problem and asking the mediator, so come please and quickly find out, okay, a solution. No, he cannot or she cannot find or reach, okay, a resolution if you want in this approach. We have to analyze the case early. We have to see, is the mediator able, for example, to settle the dispute, taking into consideration, for example, the case, the element of the case. Did we, for example, put all the elements, all those elements on the table? So we have to analyze the case before going through. So, four, we have to prepare an effective mediation statement. And here is very important. Maybe someone of you will ask me, okay, Mr. Salam, why, or in case we fail to reach out, okay, a resolution, okay, so why wasting our time? Or we have to destroy, or to throw all the elements, all the debates that that have been done, okay, during the mediation. No, it's not correct. It's false. Why? Because the mediator or the mediators and the litigants or the parties, okay, they have to do all their best, okay, to reach through the mediator a settlement. In case they fail to reach such settlement, okay, they will use those discussions, okay, for the next step. I will explain it further. If, for example, okay, we refer to a mediator a case about a rent agreement, okay, so first of all, in the mediation, we agreed, okay, that the rent is, for example, $10,000 per month, okay, but we have, let's say, a dispute regarding about the terms of payment, okay. We can, for example, or we said that, okay, we will pay, for example, in 2 or 3 installments, for example, per month, okay. Then we refused, okay, or we refuse now, okay, to pay. But before, or previously, okay, we have been for example, in full agreement that the rent worth for example, 10,000. Okay, that we agreed on the installments, on the terms of payment. So we can use those settlements. Okay, what in any or in the future dispute, with very important remark and observation, but we cannot oblige any one of the parties to use it as an argument or as a proof against, okay, the person who said or who presented this proof. It's very important. It's very important. But all of those evidence will be useful so far. So this is for point number 5. For point number 6, okay, no, this is, we finished point number 4. Number 5, conference call before mediation. Why not? Why not? We can, for example, okay, call the mediator, okay, and make a conference call with him. Okay, here we are not talking about the impartial or the partial of the mediator, because he's not a judge, he's not an arbitrator. He's a person who wants to help us. Okay, so it's an amicable solution. Okay, so that's why we can call him. We can make a conference call. Why? Eye contact. Okay, we can also sit with the other party in the presence of the mediator, asking that before going to the mediation session, okay, let's see how we can reach out an agreement. So we can do it, and it will help. So 6. Okay, 6, 7. Okay, master mediation etiquette. So it's very important that we have an etiquette to be respected. Okay, we have to respect. Okay, the ethics. Okay, we cannot, for example, aggress the mediator. Okay, we cannot be very hard with the mediator. We cannot be very rude. Okay, with the mediator. No. Why? Because any rudeness, okay, any aggressivity, okay, can, as I told you before, destroy all the process or all the procedure. We have to be nice. Okay, we have to respect the etiquette. Okay, because as I told you before, the mediator is not an enemy for us, like the judge, like the arbitrator. We have to respect him. We have to be very nice with him. Okay, because the gentle, not the gentle agreement, but the gentle behavior that we can show to the other party before and then to the mediator can for sure reduce the tension, okay, in this litigation, and can bring us to a settlement, to a fair settlement in favor of everybody. So still 2 points. Okay, 8th point, decide who will attend and who will speak. As you know, okay, we have to organize the session. Okay, so because it's not organized by law, we are not in a tribunal. Okay, and we have to go, for example, and we have to attend, for example, an audience where the judge with their with the prosecutor, okay, the parties in litigation, their lawyers, okay, the number of the audience, etc. No, we are not in a tribunal. We are not in a state court. It is an amicable session or amicable solution so far. So that's why we have to organize all of this. Because, if, for example, we are preparing to a mediation, okay, course or to a mediation session, okay, I will bring 4 lawyers, and the other party will not bring his lawyer, and he will bring, for example, his or her family. So this noise, okay, can delay, okay, or can also destroy the mechanism. So no, we need to be organized. We need to know who can attend exactly and who cannot attend, who will speak. Okay, for example, I will see that, for example, X will speak now, Z will reply, the mediator will speak, for example, at the end. The presence of the lawyers is not a must, okay? But it's preferred that any one of the party bring his lawyer, her lawyer, okay? Same for the other party, as you know, because the lawyer usually, they will facilitate, okay, the debate. They will facilitate also the task accomplished from mediator in order to reach the settlement. And the last point in my fourth topics in my presentation, okay, we have to be prepared to close the deal. Look, and this is very important. Okay, I told you before that we have 5 steps for mediation. The last step in those 5 steps is the settlement, because no need to waste our time if we will not reach a settlement. Okay, it's clear. Okay, so the same here. We have to be prepared to close the deal. If we are not prepared, okay, to end up the debate, to end up the litigation, if we are not prepared to ask the mediator, okay, to finalize the issue, no need to waste our time, because he will not enforce us, okay, to reach an agreement. He will not enforce us. He will not sort a decision, okay, to execute, enforce the solution. No, we are, as I told you before, in a circle of friendship, of amicable solution. So it's very important, psychological wise, okay, and physical wise. Are we ready to end up the session or to end up the mediation, okay, with an outcome? What is the outcome? The settlement, okay, the decision, okay? Yes, we have to be. Otherwise, no need to go through the mediation. Let's go to the arbitration, because it's a formal and it's an obligatory process. Or let's go directly to the state court. As I told you before, there's a police, there's an execution bureau or execution tribunal, and also there are judges. So it's very important. In conclusion, I advise everybody, okay, to use the ADR, the alternative dispute resolution. Okay, we can start by the conciliation. If we need something more serious and more formal, we can use the mediation skills. Then we can go to the arbitration if we need it very serious and very not just serious and very formal. Okay, the alternative dispute resolution, the ADR, as I told you, are an alternative way to settle our dispute. Okay, and it can replace, and it's replacing and somehow the justice, the state court. And it's very important. We have to learn up about the elements of mediation. Please use also the reference, go to the books, go to the law or the organization who are like the great and the esteemed organization which is organizing this debate, okay? And try to learn up as much as you can, because the mediation is very important, and later maybe you'll use it as one of 3 alternative dispute resolution on a formal basis. So hope I succeeded to explain as much as I can, okay, the mediation and the role of the mediator, the necessity of the mediation, while the time is short, I know this, but hope also that we can have the time, okay, to discuss it through other or further sessions if the organizers will allow us. And final word, please, if you have any question, I will be open and I will be at your disposal. And after the session, if you have anything to ask me, you can ask the organizer. They have all my addresses, email, WhatsApp, etc. Thank you very much, and I will give you the floor.
Thank you, Dr. Salam, and for sure we will have in the future other webinars together. Thank you. Now we will take some questions from our lovely audience. So the first question is, what is your experience in the practical field? What advices can you give us if things went south? So the question is, the first question is, what is your experience in the practical field, and what advices can you give us if the things went south?
Sorry, I'm not hearing anything. Hello?
Can you hear me, doctor? Hello, can you hear me?
Sarah, can you hear me? Hi, Sarah. Yeah. Can you hear me?
Yes.
Okay, so I'm just checking if the problem is from our end. Dr. Salam, can you hear us? I think there's a technical problem with Dr. Salam, so we're contacting him right away. We apologize for this technical issue. Thank you all for sending your questions in the chat box. We're sorry for the delay, but I'm pretty sure Dr. Salam will be very happy to answer all of your questions. Dr.
Okay.
Salam, can you hear us?
I'm reading your questions. Okay, thank you very much. Also, thank you for the compliments. Really, it's an honor for me to hear those compliments from your side. So, okay, there's a question about Singapore and about the law, applicable law. In fact, as I told you before, we can make the mediation under, for example, the Singapore law in case the dispute and the parties are locating in Singapore. But it's a question of international trade. So we can, for example, let's say the French law, the Dutch law, the USA law to be implemented. So it's not a big deal. For the second question about Lebanon, we are working to establish formal organization and to have also a formal law or a specific law like arbitration in order to organize the mediation. So yes, what else? Wait, please. Okay, so when mediating in a certain case, does the mediator have to be an expert? In fact, yes, this is advisable because the mediator is one, let's say, one of the people, okay, and in order to settle a dispute or to reach an agreement between two parties, he at least should have, okay, a knowledge about the dispute. No need to be an expert, but at least to have the less information about this one. But he can be, for example, for sure a nice guy or someone knowledgeable, etc. But yes, I think he should be not an expert, but at least he has some knowledge about the dispute itself. So, okay. So,
Okay, I think we have a technical problem. We're sorry for that. I think it should be solved in 1 minute. We're sorry. Please be patient. We are working on the issue.
Everyone, we are extremely sorry for the delay and the technical problems we are experiencing. If Dr. Salam doesn't come back, we will be very happy to receive all your questions by mail. We will be sharing the email address in the chat box. And in this way, Dr. Salam can answer all of your questions without any interruption, all right?
so I think, sorry, maybe the end. Okay, so yes, I am there. The internet was a little bit slow, but now I'm well. So if you have the further questions, I'm ready.
Hello, Dr. Salam, can you hear me? Hi, Dr. Salam, can you hear me? Hello? Hi, Dr. Salam, can you hear me or see me? All right, everyone, I think we have some internet connection problems. Dr. Salam, can you hear me? Because I think I can hear you. Okay, so I think we will just wait 1 more minute. And Dr. Salam, hi, can you hear me? Dr. Salam, hi, can you hear me, see me? All right, everyone. We are very sorry for the inconvenience. We hope you have benefited as much as we did from the content and the information Dr. Salam has shared with us. He cannot hear us. He just messaged us that he is unable to hear us, so he will be receiving all your questions by mail. We will be sending in the chat box. We did already send the emails of Mediate Guru, and you can definitely contact us by social media handles.
اوكي رباد. طيب ما بعرف، بعتقد
We can hear
الهوا ما
him.
عاد لإلي ايه حتى اقول لهم
Alright.
باي، وبليز
Dr.
بس
Salam,
تخلصي
hi.
قولي لي شو الفيدباك. يلا باي.
Okay, so then again, we will be sharing in the chat box his emails, and we thank you all for being with us, and we definitely thank Dr. Salam as well. I wish he was able to hear us, but he cannot. It's okay. So don't forget to attend the webinar organized tomorrow as a series in the workshop organized to receive your certificates after filling the feedback form tomorrow. Thanks a lot, everyone, and we wish you a great evening.